Hello everyone. Welcome to the Law of Torts lecture series. My name is Abhishek Singh Negi and today we are going to talk about environmental tort. First of all, we need to know that how environment law and tort law both are converging. As we all know that tort law as well as environmental law both are separate stream. But there are certain convergence points when they converge. And those convergence points are when some environmental hazard has happened and the person seeks a remedy. The remedy is with regard to the compensation, and here the role of tort law comes into picture. So also environmental tort is a emerging field where now the people through the environmental degradation, environmental pollution started proving to the court that this is also in a way is nuisance. This is also in a way negligence. This is also a trespass. So through case laws we'll see today that how environmental tort developed in India, as well as how environmental tort has been perceived in the world. So basically, first of all, we need to know that what do we mean, what do we understand by environment, and what is the definition of environment. So we are taking the definition of environment from Environment Protection Act. Section 2 talks about it, and section 2 says that environment means air, water, land, and human being, and the interrelationship between them. Now the interrelationship is creating a problem. Why? Because of the overuse of certain resources, sometimes we see environmental degradation. So in India, it all started with the recognition by the Justice Krishna Iyer in Ratlam Municipal Corporation case, where in the first time in India, the environmental degradation, the environment pollution has been assessed with the lens of nuisance, public nuisance, and through Krishna Iyer, the court held that yes, this environment pollution is also a nuisance, public nuisance. What is public nuisance? Public nuisance is basically that whenever the inconvenience is caused to the public by the act of someone or some authority, then it is called public nuisance. In Ratlam Municipal Corporation, the municipal corporation could not be able to clean the roads of the municipality, and that is why the omission of the work with the important work of the municipal corporation is held that this is public nuisance. And the first time in the landmark judgment of Ratlam Municipal Corporation, the court said that this is public nuisance. For example, in St. Helen Smelting Company versus Tripling, here also the court said that here also the court extended the definition of public nuisance, where the court said that yes, fumes, for example, in this case, the facts of the case is the fumes, smoky fumes are coming from the land of the neighbor, and because of these fumes, the trees of the neighbor started polluting, and the degradation of the environment was visible. And the court said that yes, if the fume are affecting the trees and shrubs, and that is why the environmental for example, the fumes are polluting the environment, are affecting the trees and shrubs, and that is why this is also the inconvenience caused by the fumes. That means the inconvenience is also caused by the activity of the neighbor, and that is why this is also held as the public nuisance. For example, in Vellore Citizen Forum case, the waste of the tanneries are being directly dumped in the rivers of and lakes of the Bangalore city, which started polluting the water of the Bangalore city. And the water, as we all know, the water in the Bangalore, because of the scarcity of water in the Bangalore city, the clean water got scarce because of the tanneries, as tanneries are started polluting the water bodies of the Bangalore city. And the court said that yes, this is also in a way nuisance created by the tanneries, and tanneries have to pay the compensation to the people, and or the compensation to the government, as they have polluted, they have done the public nuisance. Moreover, there, for example, in the case of Kamal Nath, where the court held that through public trust doctrine, the court tried to explain that public being the trustee of the nature, all the people are the trustee of the nature, and we must act as if we are the trustees, and we do not do such functions, such we do not we should not involve in such functions where the nature got polluted, because we are the trustee of the nature. Through us, the environment protection can be led by the government, and that is why the motels as planned in Bias River, banks of the Bias River, were said that this is environment degradation. This will degrade the environment, as the building of motels in the river bank of Bias would lead to that. For example, the way or the surroundings of the Bias River could get affected, and that is why this is also through public trust doctrine the convergence of environmental law and tort law could be visible. Also, for example, strict liability and absolute liability cases. For example, in Rallance versus Fletcher, also the court said that the court held that this is the case of nuisance. Why? Because they extended the definition of nuisance and held that if there could be a possibility that the person involved did not have had any fault with respect to the case, but if through the words of the Justice Blackburn, he said that if a person bringing or storing or collecting something which could create mischief, if escaped, that person must keep that thing into it at his own peril, and if that thing escapes, then the person is answerable, no matter the fault, no matter he has taken all the due care or not, no matter he has done any wrong or not, he would be held liable. For example, in Rallance versus Fletcher, also the Rallance and Fletcher both are neighbor to each other, and because of the construction of a reservoir by the neighbor, and due to the negligence of the engineer and the construction people, they could not foresee that the land of one neighbor is internally linked to the shaft of the neighbor, and in a way the water seeps into the land, and connected, as the shaft is connected with the mines of the neighbor, the whole water of the reservoir went to his neighbor, and it damaged the property of the neighbor. Here also, the person did not know that the land is internally connected to his neighbor, and that is why, as he did not had any fault, through no fault liability, the extension of nuisance definition, he was held liable by the court. For example, in absolute liability cases also, for example, in MC Mehta case, where the Shri Ram Fertilizers company, in the company of Shri Ram Fertilizers, the oleum gas was leaked, and many people died. Here, the court gave the stricter punishment than the strict liability, and held that this is the case of absolute liability. As in strict liability, for example, there are certain areas where the person could not be held liable, as for example there are certain exceptions to the strict liability. But seeing the hazardous nature of the factory, the hazardous activity involved by the company, the court said that here the company should not be escaped through the exceptions, and said that no matter what is the reason for the escape, no matter if the thing is actually escaped or not, if because of the hazardous work undertook by the company, and because of that work, if somebody is affected, no matter what is the reason, the company has to give the compensation. That means the company is absolutely liable, no matter whether the company has done any wrong or not. For example, there are many. So after the evolvement of many case laws, environmental case laws, where the compensation has been sought through through claiming tortious liability to the defendant, the court started evolving and entertaining the cases regarding environmental degradation. And still now we have reached to a level where we have evolved another tort called toxic tort. For example, in toxic tort, the court sees that if the person is involved in hazardous activity, and because of that activity, if the person is getting affected because of the toxic activity done by the defendant, then through the toxic involvement of toxic tort, the person could claim the damages. So there are many cases which shapen the new liabilities under tortious law, and under tortious claim, now we could be able to prove that if there is through environmental degradation. For example, in Rambrit Singh versus Babulal, here also the court first time held that the grinding of bricks, because of the noise producing during the grinding of the bricks, the neighbor got disturbed, and the neighbor of the factory sued the factory because of the nuisance they are creating. The court held that yes, this is the case of the noise pollution, and noise pollution is very much relevant in today's world as the new kind of nuisance to the neighbor. And through this judgment, the court held that noise pollution is also a kind of nuisance. Thereafter, in Free Legal Aid Cell versus Government of NCT Delhi, here also the court banned the loudspeakers and said that during the festivals and marriage celebrations, there are certain activities which are undertaken by the people, which causes noise pollution, air pollution. For example, burning of crackers, for example, playing of loud music. Should be restrained, should be banned by the government. And this is why, and through this case law also, the court started recognizing that air pollution or noise pollution is also a kind of nuisance. Moreover, for example, in Sem-II versus state of Tamil Nadu, where the child fell down to the sewage pipe, as sewage pipe was kept open because of the construction of the government highway and metro station. That is why the court said that the keeping open of such a keeping open of sewage pipe, and the child falling into such pipe is also a negligence on the part of the state, and the state must compensate to the parents of the child. So these are the things where, for example, in news cases of nuisance, noise pollution, air pollution, land pollution, the court time and again, through the involvement of tortious liability, establishes that environmental degradation is also a tortious act. For example, in negligence cases, for example, Rylance versus Fletcher, MC Mehta versus Union of India, there are many cases where the court held that if the person is involved in an activity which eventually affects the environment, the person can surely claim the damages and surely set the tortious liability on that person. So these are the case laws through which the tortious liability and environmental law, they converge and gave rise to environmental tort. And as I have already discussed, that there are certain toxic tort, the certain new emergence of new torts. For example, toxic tort is the latest emergence of tort, where the the court prima facie accepts the case in the name of if the party is involved in ultra hazardous activities. So these are the case laws. I hope I'm clear. Thank you so much.